All right, we could go ahead and get started.
All right, I'd like to call this meeting to order. I'd like to do a roll call of the members attending. Member Vest,
Present.
Fauber,
Here.
Mullen,
Here.
Powers, and Pufall is here. Okay.
I am anticipating Mr. Powers joining us. He might be running a little late, but
all right.
we'll make note of that.
Thank you, Chris. In addition to citizens attending the meeting in person, citizens have several options to view or participate in the Zoom meeting webinar as described. We do our best as citizens to allow citizens to comment remotely. There are two options for citizens to offer comment. Join the Rockbridge Board of Zoning Appeals Zoom webinar. The link is available on the county website for you to copy your the address into your web browser. You may also join by telephone. Dial in one of the numbers listed on the county website. Webinar ID and password are there for your convenience. If you wish to make a citizen comment as a Zoom meeting participant, you will use the raise your hand feature. You can press the raise your hand button on the bottom of your Zoom window or press *9 if you're calling in by telephone. At this time, I'd like to proceed with the meeting. BZA electronic participation policy resolution.
Yes, sir. And in your package, you have a resolution pertaining to the Board of Zoning Appeals electronic meeting policy due to some laws and due to some changes in the Code of Virginia, we're now required to annually adopt this. So we're doing that for this calendar year we're going through there.
Okay.
It does require a motion and a second and as noted, a roll call.
Okay. Has the board had an opportunity to look over that section? All right. Motion is required.
Yes.
Yep.
I'll make a motion to approve.
All right. Motion made to approve.
A second.
All right. All in favor? Aye.
Aye.
Okay. Motion carries.
Unanimously, correct?
Yes, sir. All right. Election of officers.
Same thing. There's some procedural housekeeping type items. Since this is your first meeting of the calendar year, you're required to do election of officers. This does require a motion. Currently, I believe Mr. Pufall serves as chair, Mr. Mullen as vice chair, and I, as the zoning administrator, are required to be the secretary.
Okay.
And it could be done in one fell swoop. You could make a motion to include all the same as the last calendar year if you like.
Anybody want to be chair? All right. Anybody want to make a motion to keep everything as is? Moved. All right.
Second.
Second. All in favor? Aye. Looks like we've got a motion. Next on the agenda, I believe, is the approval of the 2026 Board of Zoning Appeals meeting schedule.
Yes. So again, it's housekeeping item at your first calendar meeting. The Board of Zoning Appeals adopts the meeting schedule for the coming up year. As always, the Board of Zoning Appeal meetings will be held on scheduled on the third Wednesday of the month at 7 p.m. on an as-needed basis. Let me follow through. And so in your document, you have the proposed schedule for 2026. And looking at it, reviewing it, there are no state or federal holidays on that third Wednesday of the month.
All right. This requires a motion.
It does.
Okay. Upon review, anyone would like to make a motion?
I move to approve the zoning appeals meeting schedule as published. Second.
Second, okay. All in favor?
Aye.
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 And for the record, Mr. Powers is now here, present.
Can I apologize? I got stuck behind a overly cautious driver.
Okay, fair
on some
enough.
foggy roads.
Yeah, I understand. We appreciate you.
Yes. All right. Next on the agenda are the minutes from the last meeting, which was November 19th, 2025.
Yes, and that was, as you recall, that was just we're required, the Board of Zoning Appeals is required by state law to hold one meeting a year. And so that was our annual meeting, and it was just housekeeping items. So their minutes were fairly cut and dry, if you will.
Yeah. This requires a motion.
It does.
I move to approve the minutes as presented.
All right. Seconds.
Second.
All right. All in favor?
Aye.
Aye. Opposed? All right. Motion carries.
Abstain, so having not been there.
Okay. Thank you. Okay. Next on my list is the Warm Run Citizens Association LLC and Rockbridge Taxpayers Alliance Incorporated. Appeal of the zoning administrator's decision pertaining to Warm Run Solar LLC.
Yes, staff has a brief presentation. I'm going to actually read the notice of public hearing first of all, to get that out of the way. Somewhat housekeeping. Notice is hereby given per section 15.2-2204 of the Code Virginia and section 808 of the County of Rockbridge Land Development Regulations that a public hearing will be held by the Rockbridge County Board of Zoning Appeals on Wednesday, February 18th, 2026 at or after 7 p.m. In the Board of Supervisors meeting room located at the County Administration Offices, 150 South Main Street, Lexington, Virginia, 24450. To consider an application for appeal of a zoning administrator's decision by Warm Run Citizens Association, LLC. Mailing address is 136 Warm Run Road, Lexington, Virginia, and the co-filers, if you will, the Rockbridge Taxpayer Alliance Incorporated at 1004 Waterloo Drive, Lexington, Virginia. The appeal pertains to a decision of the zoning administrator related to the interpretation of the conditions associated with a previously approved special exception permit to develop and operate a 3.00 megawatt AC power solar project. Property is identified as tax map number 62-12-B1 and is located on the east side of Lincoln Road, further identified as State Route 763, approximately 0.52 miles south of the intersection of Lincoln Road and North Lee Highway. North Lee Highway is course Route 11. Property is owned by Robert F. Huffman, trustee. His mailing address is 1318 Mount Atlas Road, Lexington, Virginia. The property is in the South River Magisterial District. The notice of public hearing goes on to say a site visit may be made by the board at or after 4 p.m. on the day of the meeting, and all of y'all were present for that. Everyone, excuse me, except for Mr. Farber was present there. That was advertised as a public meeting notice, and that was advertised in this building, separate from the requirements of notifying for the special exception. It goes on to say additional information concerning the application may be obtained by the Office of Community Development, 150 South Main Street, Lexington, Virginia, or by calling 540-464-9662. So a little bit more about the property itself. Again, the property.
Chris, maybe it might be helpful just for everybody to understand if you could explain real briefly what the structure is of this hearing, the 5 minutes, 15 minutes, and how that will proceed.
You want to?
What shall I do?
Yeah, absolutely, yes.
So just to make it clear for the members of the BZA and for members of the public, the way the hearing is structured according to the bylaws of the BZA is that the county will have 5 minutes to introduce the facts of the case and to state by law, we have to state the reasoning behind the zoning administrator's determination. Then the appellants have 15 minutes to state their case and present evidence. The county then will have 15 minutes to respond and rebut and present our case and our evidence. And then the appellant will have 5 minutes to respond to what the county has to say, at which time the BZA will then have the opportunity to discuss this and ask questions, then move into closed session to have further discussions. So just to clarify so everybody understands, and there will be a public hearing that's opened up after the close of the presentations by the appellant and by the county. So there is an opportunity for people to speak during the public hearing.
Thank you.
Thank you.
Absolutely.
The sign up sheet is on the table.
And there's
for
sign up
the
sheet on the
public
table.
hearing.
People want to speak, so there's an opportunity for the public to speak.
All right, and I apologize. I failed to put my PowerPoint on up there on the screen. Wasn't necessary till now. Again, the property is owned by Robert F. Huffman, trustee, mailing address of 1318 Mount Atlas Road, Lexington, Virginia. The 3.00 megawatt AC power solar facility is proposed to be located on approximately 34 acres of the Huffman tract, further identified as tax map number 62-12-B1. That property is outlined in yellow here. Consists of 56 acres per tax records. In addition to the outlined parcel, again, 6212B1, Robert Huffman trustee owns 2 adjacent parcels to the south and 1 adjacent parcel to the north. On November 24th, 2024, the Board of Supervisors, the Rockbridge County Board of Supervisors approved a special exception permit for the development of a 3.0 megawatt solar facility for Warm Run Solar LLC. With the special exception process, once the application is deemed complete, the application is placed on a planning commission's agenda. After holding a public hearing, the planning commission makes a recommendation to the Board of Supervisors. Its recommendation can include imposed conditions that are associated with the proposed land use. The Board of Supervisors is also required to hold a public hearing, and the Board of Supervisors has the ability to amend, remove, or add conditions. The approval of the Warm Run Solar project included 21 conditions. There are various stages when the conditions are required to be met. I'll go here. Sorry. Sorry, but my sheet didn't print it all. There are various stages when the conditions are required to be satisfied. The approval of the special exception was a legislative action. There are several regulatory actions that are required prior to the start of construction. They include obtaining a site plan approval, that would be with the planning commission and staff, if you will. Land disturbance permit, stormwater management and erosion and sediment control permit, a building and zoning permit. Some of the conditions are associated with the special exception permit are required to be satisfied during the site plan approval process. The majority of the conditions are required to be satisfied prior to the Office of Community Development approving the zoning portion of a building and zoning permit application. Lastly, some of the conditions are required to be satisfied post-construction. While I have not, as a zoning administrator, issued a formal written determination, I did determine that the ground condition testing associated with the racking foundation company activities were not construction. The testing activities were not construction, and additionally, nothing has been constructed on the property. Test holes were drilled, test the ground conditions. When the post was then removed, and the hole or the drill screw was removed, and the holes were filled. It was confirmed with the erosion sediment control and stormwater administrator, Jonathan Griffin, that the work did not require a land disturbance permit. And lastly, it was confirmed with the building official that a building permit nor trade permit was required for the testing of the ground conditions. At this time, I'd like to turn the floor over to Mr. Bill Russell with the Rockbridge Taxpayers Alliance, Incorporated.
Mr. Chairman, members of the zoning board, my name is Bill Russell. I am actually the founder and president of the Rockbridge Taxpayers Alliance.
Bill, could you step closer to the mic?
Sure. I had a question, part of which has been answered. So I understand, for the record, there were 4 members of the board present at the site plan visit. I wasn't present, and I don't know the substance of any discussions, questions, answers, or explanations that may have occurred. I respectfully request the board's decision be based solely on the evidence and arguments presented on the record during this hearing. To the extent any substantive information or explanations were provided at the site visit, I also respectfully request that any such information be stated on the record so that the hearing record fully reflects the information considered by the board, particularly in view of the fact that 4 of you were at that site visit. And I know that a site visit is not an unusual thing. So, and I'm going to excuse myself here for one thing. I just had cataract surgery about 2.5 weeks ago. I can see great if I'm driving. I got 20/20. They have not gotten my glasses for near vision ready yet. So I'm reading this kind of through my old glasses, looking at little things bouncing up and down in my eye. Anyway, Rockbridge Taxpayers Alliance is a nonprofit, nonpartisan public interest organization composed of Rockbridge County residents. The only requirement for membership in that group is that you be a Rockbridge County resident over the age of 18. We have no dues, fees for joining the organization. We're primarily focused on issues of government transparency, fiscal responsibility, and governance issues. We appear in this matter not in opposition to any particular land use in the abstract, but to address whether adopted board conditions are applied according to law. Warm Run Citizens Association was a co-appellant here as a nonprofit neighborhood association of residential farming families surrounded by the Warm Run community immediately adjacent to the proposed Warm Run solar project. Several of the Warm Run members are also members of Rockbridge Taxpayers Alliance. The appeal concerns whether the zoning administrator's December 15th, 2025 determination that installation, drilling, and foundation load testing did not constitute construction activity requiring prior board satisfaction of board-imposed conditions was correct under the governing statute and the board's adopted special exception permit. To clarify at the outset, this appeal does not seek to compel enforcement action or supervise staff discretion. It asks the board to review the interpretive determination under Virginia Code 15.2-2309. I think that's in the packet, but I'm not sure. On November 25th, 2024, the board approved the special exceptions subject to, as Chris mentioned, to a series of 21 conditions, including a well protection financial assurance requirement that is intended to cover one of our members, who's a member of both Warm Run Citizens Association and the Rockbridge Taxpayers Alliance, in the amount of $30,000 in case construction activities occur because his wells are so closely placed to the line adjacent to the field in such a way as to damage the wells. And I feel I'm the one that brought up part of these condition discussions, both at the Planning Commission and at the Board of Supervisors. And I also made some suggestions about the amount involved there, because our concern as the Taxpayers Alliance in this was the well-being of one of our members. We also have some other members, some of whom are present today, who have a variety of different interests there, but we're concentrating on the effects on that one member. On the 15th of December, 2025, installation drilling occurred. The county manager described hammer down drilling into rock, oversized holes, installation of and load testing of foundation components, and backfilling. That was carried out by a rack construction company that builds and emplaces racks for the solar panels themselves for the system. The zoning administrator determined that this activity did not constitute construction. The question we're bringing before this board is a very narrow question. Whether installation, drilling, and foundation load testing required prior satisfaction of the board's adopted construction precedent conditions. And in other words, was this in fact construction? pre-construction construction? Is it a construction phase? We submit that under statutory definitions of land disturbing activity and under the binding nature of adopted special exception conditions, the determination was incorrect. I will briefly outline the documented sequence and the governing framework. And just kind of going along with something Chris did, I have a little timeline of what happened here. And frankly, had the installation occurred, we may not, as the Taxpayers Alliance, may not have been in here. But as was said already, the special exception was conditionally granted on the 25th of November, 2024. This installation activity occurred on the 15th of December. On the 16th of December, a written request sent to the county manager, county attorney, and zoning administrator asking whether board-imposed conditions had been satisfied prior to drilling, the basis for allowing the drilling activity, and which conditions remained unsatisfied. That was from me, and so far I have not gotten any contemporaneous written response to my written inquiry on that matter. There were other issues involved here. We are not addressing those other issues. We just want to stick to this narrow issue of the activities on that day and the determination that was transmitted to the on-site contractor there. What they were doing was permissible. We jointly filed an appeal on January 8th with the Board of Zoning Appeals challenging the determination. We have filed supplemental statement on the 3rd of February, an addendum, and most of those to the addendum on February 6th was basically a copy of emails, and Chris had already placed a copy of the emails in addition to which in the county record. And then we have filed subsequently some other documents in this proceeding. And I want to address a couple of things in order because part of the response to that has questioned the jurisdiction here, our standing in the merits. And I'll just briefly go over that. I'm going to briefly go over that because I have a page missing of it and a copy of it right behind me. I'll address the jurisdiction first. And I think standing I can do subsequently, and I'll go pick up the copy of it on the merits. The appeal challenges the determination made on December 15th that the installation and foundation load testing did not constitute construction phase or land disturbing activity requiring prior certification of board imposed conditions. In other words, our contention is that those conditions needed to have been addressed before this activity occurred. The determination authorized the activity to proceed under Virginia Code 15.2-23091. The Board of Zoning Appeals has authority to review determinations of the zoning administrator. This appeal does not seek enforcement action. We're not asking you to take enforcement action, anything. We're strictly looking at the determination. It seeks a review of the classification determination, the classification being how this was determined, whether it was determined as pre-construction, construction, or testing as the case may have been presented. Virginia law distinguishes between enforcement discretion and reviewable interpretations of ordinance or condition. We believe that this was an interpretive classification decision, and I don't think that's disputed. It may be, I'll see. It is properly before this board. Standing, and I think that was brought up in the relationship to the Rappahannock decision of the Virginia Supreme Court. we do have, and we have present the member who the county recognized and took action, the Board of Supervisors, to impose a condition to protect that particular member adjacent to the solar site from any damages occurring as a result of the construction of the solar field. And it certainly, and they put $30,000 requirement of essentially a bond up there to help indemnify him in case that happens. So certainly, I think you have to take into account and accept the Board of Supervisors understanding and determination there that there was a risk and that there's a potential for economic loss and harm loss certainly to the member that we have here. We believe we meet the standing requirement. And if you will just indulge me for a second while I find the second part of that.
Just to make clear, Mr. Russell has just a few minutes left. However, the board can extend the time if you desire.
I do have some supplementals that I want to get into, so I'll just say the merit issues are narrow. Whether installation or drilling and foundation load testing constituted land disturbing and construction phase activity that could not lawfully proceed prior to the satisfaction. The written record establishes what occurred, and I think it's pretty clear in there. We have their work order. The county has put in also in some of the communications what occurred. Virginia Code specifically defined land disturbance activity to include excavating and filling. Drilling that removes subsurface material and creates cavities requiring backfill constitutes excavation in ordinary usage. The statute contains no exemption for testing. The board imposed construction phase protective conditions, as I mentioned, $30,000. The record contains no contemporaneous written determination that those conditions had been satisfied prior to drilling. And we did ask about that. The presumption of correctness under 15.2.2309 is rebutted by the greater weight of the written record. And a lot of this, we believe, is in the written record and readily determinable by the board members. The issues of jurisdiction, standing, and merit are properly before the board. So the determination of the 15th is reviewable. The activity at issue constituted land disturbing and construction phase activity under the statute and the board's adopted conditions. We believe the staff determination should be reversed. That's the only remedy we're seeking. I'm gonna reach beyond the legal things that I just covered and cover a technical memorandum that's included in your packet that cites quite a few standards from standard setting groups, engineering classifications from the Federal Highway Administration, utility scales conservation practices, construction sequencing context, regulatory definition of construction, distinction from preliminary site investigation, relevance to conditional special exception compliance, and in conclusion, the installation and lateral load testing of embedded ground screws performed by a solar racking contractor constitutes construction phase foundational activity. That is what is in the citations from various groups, including several federal agencies, and the common usage in the construction industry, even by racking people. And I have included in that packet an example of that from a contractor who has done racking business in Rockbridge County and defines construction within their website. And it's in there as one of the portions in the back. I think we have substantially brought before you a great deal of relevant information here and tried to create a record that relied on common usage of excavation, backfilling as construction. I have some background, and I understand pretty well that drilling in and of itself, particularly jackhammer drilling, is an excavation process. It brings up soil. It creates a soil disturbance. It's covered by the statutes in that language. It's quoted. I have a separate piece that's in there on case specificity related to a lot of these. I'm probably running out of time, I assume.
But you've gone a few minutes over, but the board can grant you additional
Okay.
time. So.
If you have questions, just don't rely on me to be an engineer.
Thank you.
Thank you.
Members of the Board of Zoning Appeals, we appreciate this opportunity to appear before you today and to provide the county's perspective on what took place. We especially appreciate Mr. Russell's statement that the issue before you is a narrow issue, which we agree with, as to whether or not, if a determination was made, and we'll discuss where there's one was made, if a determination was made, the only thing that you are able to do is to determine whether you affirm that determination, or you wish to modify the determination, or you wish to overturn the determination. As we get into this, my first point that I'd like to make, let me take a step back and kind of give you some of the factual things. I think they've been covered fairly well, but the question comes up as to what has actually taken place on the site. Our understanding has been provided in the package with affidavits signed by the racking company, which actually did the work, and by the company which handles the Warm Run Solar project, is that what took place was a simple testing of the foundation to determine whether or not the soils and the rocks there could handle the load of putting in the different racking systems for the solar, which is something I think you're aware of. You were able to go to the site and actually see some of the site there. And to just to let Mr. Russell know, the meeting that your visit to the site was a public meeting, and minutes will be made of that, and minutes will be publicly available. So everything will be available for that purposes. One of the things which was not addressed by Mr. Russell, but was in the conditions, is in the submissions they had, is whether or not explosive devices were used on the site. We, as a county, have found no evidence that that took place. We do agree with the appellants that that is a condition, that the explosive devices and detonations are not allowed under any circumstances to happen. We've been assured by the racking company that that is not what they've done. They explained their process in doing that, and explained that actually using explosive devices would be counterproductive, because it would fracture the rocks underneath and make them so they wouldn't be able to hold the load, or be not as stable in holding the load. I've already discussed that, and we agree with Mr. Russell that your only issue that you're addressing today. We have actually 3 issues we're asking you to address today. The first issue is jurisdiction. The reason why we're calling it jurisdiction is it's the county's position that no determination was actually made by the zoning administrator. We do use the words determination just because we want to make sure that we use the language that the appellant is using. However, and I'll explain this, that it's our belief that that the zoning administrator did not actually make a determination, and that so that their filing is actually premature. Therefore, there's no jurisdiction the BZA has. Second, we actually disagree on their position. We do not believe that either the Rockbridge Taxpayer Alliance or the Warm Run Solar Citizens Association are aggrieved parties. So under the statute, only aggrieved parties are able to bring an appeal to the BZA to challenge a determination. And we'll explain why we think that's not the case. And finally, even if the BZA determines that you do have jurisdiction and that they are aggrieved parties, We believe the law and the facts of the situation clearly establish that there was not, construction did not take place on the site. And we believe that's well established by law. And just to, while I appreciate the appellants submitting statements by different organizations as to what constitutes construction, we are not allowed to follow that. We have to follow what the law says. We have to follow what the statutes say. We have to follow what the ordinance itself says, and when we have to follow what the Supreme Court has said as to what constitutes construction. And there's clear precedent in this area to establish that no construction took place. First, I want to address the issue of jurisdiction, whether or not a decision was made. The record shows that the only indications that the zoning administrator actually made a determination came from 2 emails. These emails were not from the zoning administrator, but from our county administrator, from Mr. Suter. Mr. Suter handled discussions, most of the discussions with the appellants. The reason why, as you know, is that our zoning administrator has spent a good bit of time in the hospital to get treatment for his cancer. And during the period of this time, several of the calls to him were while he was actually in the hospital receiving treatment. One of these emails was dated December 15th, and the other one was dated December 17th. In the December 15th email, the county administrator wrote, "I contacted the zoning administrator, Chris Slayton, who was in treatment at UVA via phone. I explained the process, and he opined that this process, and this he was referring to the processes which were taking place on the site, the drilling and other things. I explained the process, and he opined that this is allowable under the existing special exception permit." In the second email, which makes a reference which might be construed as a determination. On December 17th, the county administrator stated, "With regard to your message yesterday," and this was an email addressed to Mr. Stout, who is the president of the Warren Solar Citizens Association. And it is a resident close by. He's within, not right next to the property, quite close to it. And this is a response to Mr. Stout's early email asking why the county allowed the solar racking company to continue testing after they've already raised some issues as to why they think that they shouldn't be able to do that. And Mr. Suter said, "I confirmed with the zoning administrator, Chris Slayton, and county attorney, John Dryden, that the testing activities were not construction." Those are the only 2 statements we have that we could hang a hat on, say that they might be determinations. At no time did the appellants, and this is important, at no time did the appellants request a determination from the zoning administrator on the issue of construction. That we never got a request for an official determination, and I'll provide what they actually asked. Their communications were focused on demands that the county put a halt to the testing activities, that they're providing their interpretation of the law as to why we had to put a halt to the testing activities, and for a written explanation for 3 questions. These 3 questions were all of the board meeting, I assume means the board of supervisors, were all of the board approved conditions met before you gave approval for the foundation testing in the previous provided APA is the name of the racking company, in the previously provided APA work order. Number 2, if not, what forms the basis for staff decision? Number 3, finally, precisely what conditions have not been met? In our reading of that, that is not a question. For the narrow question, which he says our question before us is, do these pre-construction activities, do the activities that took place upon the site by the racking company constitute construction? We were not asked that question, though that is the question they say that has been brought before the board. As we were not asked that question, I don't believe that the county zoning administrator was required to make a response. However, given that we tried to be as open as possible and provide responses, we did actually provide an email, which has been put before you because that wasn't actually in the package, an email from me to the appellants stating that it is the county's position that they have not yet, that no determination has been made, therefore an appeal is premature. However, we are happy to treat their emails that they sent prior as a request for a determination, and that within the 90 days we're allowed by statute, we will provide a written determination. This is a very unusual case to bring before you. I think this is the only time we've ever brought a case before you where there was not a written determination, which makes things very difficult for us to even establish what the basis was for the determination. Because normally, as you are probably aware, Mr. Slayton is very thorough in his written determinations. We do not have it at this time. Because they at no time made the appellants made no request for a zoning termination, the zoning administrator and the zoning administrator's response to the zoning administrator's response, Mr. Slayton's response to Mr. Suter from a hospital bed in the UVA while he was receiving cancer treatment, did not constitute a determination by the zoning administrator, but an expression of his initial opinion. Further, the county informed the appellant of this in my January 8th email, and we said that an official determination will be provided at a later date. The response to the email was that they've provided all the information that they need to provide, and that basically they will proceed with the appeal. Therefore, the appellant's appeal to the board is premature because there was no determination actually made. Now, there is a Supreme Court case on this, which is very important. That's called Lilly versus Caroline County. And that case actually stands for the principle that determinations by a zoning administrator do not need to be in writing. They can be oral because the statute doesn't require them to be in writing. However, they must actually be, the zoning administrator must make clear the basis for his decision, and it should be seen as final. And Lilly actually supports us quite a bit, even though this isn't, we don't challenge if he did make a determination being oral isn't an issue, the fact that he stated. But what Lilly actually stood for was there was a zoning administrator who over a period of 2 to 3 years had made comments to the owner of a piece of land and to others and to the planning commission and to the board of supervisors that he believed that that the building of a radio tower on this particular piece of property was a by right use. He stated that, and then 2 years later, a year later, it went before the planning commission. And in the planning commission, he stated that he would get back to the planning commission later as to what his determination was. In the next planning commission meeting, he stated that it was his belief that it was a by right use. He then went before the board of supervisors. The board of supervisors asked him what his opinion was. He said that he would research it and present it in their next meeting. In their next meeting, he stated that it is his determination that it was a by right use, and he stated the basis for that, and he stated, which is important, and he stated this determination can be appealed to the Board of Zoning Appeals. Based off of that, the Supreme Court said that was the final determination, and they explicitly stated all the other statements he had made in the past were not determinations. So it is our position that the statement that Chris made from his hospital bed in UVA in response to Spencer, not directly to the appellants, was just an opinion that he had at that time. And we did provide an email stating when we would provide a written opinion, and we still will, because we've stated that it is that time. So within 90 days of January 8th, a written opinion will be provided. Because of this, we don't believe that a determination was actually made. The second part, I'll go through this fairly quickly to get within the time frame, is the question of standing. Mr. Russell did state that and this is the first time it was stated, it wasn't stated in the other records, that the Rockbridge Taxpayer Alliance does have members who live in that area close to it. And we'll accept that at face value. Normally we'd ask, for proof of that, but we accept that as face value. So we don't challenge that at all. However, there's important things to keep in mind. Under the Virginia Beach Beautification Commission versus the Board of Zoning Appeals, civic organizations only have standing through their members to challenge this, and only if they can show actual harm took place. And it is our position that neither the Rockbridge Taxpayer Alliance nor the Warman the Warman Citizens Association actually are a aggrieved party. In other words, they did not receive harm. And why is that the case? And even in their pleadings, they do not plead that they received harm. What they plead in their pleadings is not that they were harmed because of the pre-construction activities which took place, on the actual activities that took place there. They're talking about future solar sites that go in there, potential damage to the well, which is a future damage, not dealt out of this. All of those situations, and it's clear that the court cases say that they cannot be based on speculative future events. It has to come from what actually is happened. And the only issue before the board right now is whether or not the racking activities, the drilling activities, constituted construction. So if they could plead, which they have not, that they were harmed because of that, then they could say they're an aggrieved party. But neither party has pled that or provided any evidence to support that. And this comes to one thing which I forgot to say, which you probably know already. that the decisions of the zoning administrator are deemed to be correct, and they can only be overturned if the appellants provide evidence to overturn it at the level of preponderance of the evidence, which is not just 51%, that's like 70, 80% of the evidence they present seems to disprove what the zoning administrator's positions were. So it's a high bar that they have to meet. And they have to, in this case, they've not provided any evidence that they were actually aggrieved by the activities which actually took place on that property. Finally, we can get to the action merits, because if it's the determination of the Board of Zoning Appeals that you do have jurisdiction and that they do have standing, then we're happy to go to the merits. And the question is there whether under the law and the facts, they have proven at a preponderance of evidence that construction actually has started to take place on the site. There are actually two very important cases on this. One is McClung versus County of Henrico, and the other one is WANV versus Huff, which is actually a case that took place here in Rockbridge County in the 70s. In both these cases, the Supreme Court held that activities such in the McClung case, it was a veterinarian who had received a building permit to start building something on his site, but then there was a change in the zoning laws, and he had to do it within a certain period of time or he wouldn't be able to do it. He actually went out there and excavated around the site. He actually even poured some footers around the site. The Supreme Court said that, and then he let it lull for a while. And the Supreme Court said that was not sufficient to be construction. So those activities did not constitute construction. He even engaged a contractor who had actually not started the work prior to the time, but that was not sufficient. And the WANV case, that's actually more of a question as to, because for the issuance of a building permit, there was a certain number of days in which you had to begin the work or the building permit would lapse. But it was still, the question was the start of construction. In that case, they also went through and did quite a bit of the land work that was necessary to do that. And the Supreme Court held in that case, no, that was not sufficient to constitute construction. So under the law, it is quite clear that merely drilling holes to check whether or not the site can handle the placement of these racks is not construction. We have statements from Jonathan Griffin, who handles our stormwater issues, and we have statements from Kenny Wilson, sorry, I know their names, but who's our building administrator, and both of them say that permits were not needed. So even though there was some disturbances, and there might claim that that's by law is required to do that, it is Jonathan's responsibility to determine and to enforce those things. If he has done that improperly, it is not the BZA that makes that determination. It's actually a separate challenge, if possible, for them to challenge at other places. Further, not only do we have Supreme Court cases that make it clear this was not the start of construction, the actual special exception permit itself, it makes it quite clear. So condition 11, it states this: all pre-drilling foundation work and or use of hydraulic hammers, rock hammers shall be limited to the hours of 7 a.m. to 7 p.m. Monday through Friday. All other excavation, construction, deliveries, and or decommission activities shall be limited to the hours of 7 a.m. to 7 p.m. Monday through Saturday. It is clear, and remember, when the Board of Supervisors passes this, they pass it as an ordinance. It is a legislative act. And so we give deference to the actual language. It is clear that pre-drilling foundation work are not in the same category as construction. And so to deem that these activities are construction would be contrary to the plain language of the special exception permit. We do agree that explosives cannot be used, and that has not been raised by them in their presentation. So we just assert that there is no evidence whatsoever, and we do have provided in the record a statement by the fire marshal and a statement by the racking company that no explosives were used, and they would have to establish otherwise. But frankly, even if they did establish explosives were used, that's not an issue for the BZA to look at, because that's not a determination issue for the zoning administrator. And we do agree that a $30,000 bond is supposed to be posted prior to the beginning of construction. We don't believe that has any bearing on the zoning administrator's determination here, because he was not asked to make that determination as to the bond. It does impact it indirectly, but that's not the issue before the BZA. So finally, that's the position that the county has. We do appreciate citizens bringing forward their comments. We do, however, believe that this, in the first case, we believe it's a premature, that there was no determination made. Even if there was, that the parties are not aggrieved because they are not pleading any damages they received because of the actual actions that took place upon the land. And finally, even if that takes place, the law is very clear. Supreme Court makes it quite clear that these activities are not construction, and even the special exception permit itself also makes this clear. So we're happy to, during your discussion time, you do have the opportunity, if you'd like to ask questions to ourselves, to the appellants. And now the appellant does have 5 minutes to rebut.
Is there any rebuttal from the appellant?
Yeah, so nobody else.
Well, I think later on, the other people can talk during the
Right,
hearing
but
time.
You have a 5-minute opportunity to talk on, rebuttal what the county has presented.
Okay, I think actually the core holding in Lilly is that a zoning determination need not be formal in written order to be appealable. BZA may review an administrative decision affecting land use. I don't see it as holding anything else. The McClung, I think those are vesting cases. They're about, and we're not challenging the vesting of property rights here. Sorry, but doesn't seem to me to be applicable. And I did address that in one of our filings, and I apologize if it wasn't seen it before that. Friends of Rappahannock, organizational standing requires at least one member with a particularized interest. It's appealable if one member is aggrieved and the issue is germane to its purpose of the organization, and I believe it is germane. And I presume that that's a point that has to be clarified, but that goes directly to that. Preponderance of the evidence is not. There's no place saying it's 80%. Williams versus Commonwealth, again, a Virginia State Court, preponderance equals a greater weight of evidence. Essentially, just a weight test, but it's not like some huge percentage of that weight. We think we meet it based on our written filing. Brown versus Lukehart, statutory language is clear and unambiguous. Courts apply its plain meaning. We're talking about what the common usage in plain meaning is. I think what it says is land disturbance is broad. And the statute is even fairly broad when you look at it. And it specifically includes excavation and filling. And our position is that drilling is effectively excavation. And filling is covered in what you said they were doing, what the county said they were doing. They were filling those holes back in. And I find in looking in a search, I could find no exemption for testing from these statutory standards. Merely because it's labeled as testing doesn't matter. Board of Zoning Appeals versus University Square Associates. Courts evaluate the substance of regulated activity, the substance, rather than a label applied to it. So again, what is common sense occurrence in construction? You can use a lot of different tools to accomplish the same thing. And here you had a jackhammer drill hitting down, I guess, 5,400 square feet down of pressure, coming back up, placing materials down there, a hook into bedrock, pulling that ground back up, that sure looks to me as if it is excavation. And it sure looks to me as if it is soil disturbance. And the statutes sure look to me like they cover that. It's the functional nature of the activity under Board of Zoning Appeals that governs. Calling something testing doesn't change how it appears. These the condition that effectively is under discussion here in condition 21, I think we have to give a presumption that the Board of Supervisors knew exactly what they were protecting. They were protecting the adjacent landowner over a reasonable possibility of something occurring as a result of construction. And I think that we're trying to avoid in a lot of ways accepting that this is construction. I've got, and I would ask you to look at some of the written material that's in there, particularly the technical, and kind of got dismissed as being relevant, the technical standards that I said in there. And those technical standards have to do specifically with the placement of structures within the ground to uphold essentially holes and putting in holes to do that. And there are standards from national organizations that are well accepted in the construction industry. They're applied by the Department of Transportation of the United States, including in this state. Anyway, that's in there. And I would ask you to look at this from the standpoint of what was practically occurring there. You know, take away all the language that's here. What was actually occurring? We know that the Board of Supervisors on the 25th of November 2024, I'm getting a little bit old, adopted a conditional grant of a special exception, and that no construction activity would take place until those conditions were met. We couldn't get an answer as to what conditions were met. As a matter of fact, in written replies to a series of FOIA questions, what we got point after point after point was no record, no record, no record. So it's a little bit difficult to us to say what other things may or may not be conditionally applied or unapplied. But we know this one sits out there because it very specifically attached to a very specific person with a very specific piece of property as an insurance against what the Board of Supervisors thought was a reasonable possibility of something happening to their property. So anyway, I appreciate your time. I would ask if you would read that material, just for the fact that I've spent a lot of hours doing the research, but I'm learning something here too. So thank you.
Thank you.
Thank you. Thank you.
At this time, we'd like to open to a public hearing. If anyone is physically present who would like to speak, if yes, Chris will call you up. There is a sign-up sheet if you haven't filled it out.
No one has signed up, but we may have some. If anybody would like to make a public comment, please come on up to the podium. Not seeing any. Absolutely, yes, sir.
Get the mic up. Can everyone hear me okay?
Yes, sir.
My name is Edward Showalter. I live at 309 Warm Run Road. I was at the hearing when this was passed as far as allowing the construction to occur. But what is germane here is that I did see a drill located on the Huffman property, and I have no idea how much that it drilled down, but I hear soil mentioned here a lot. Essentially, again, I'm very familiar with the area. There's probably 2 feet of dirt on top of who knows how much limestone. I know there's at least 30 feet of limestone because I have scuba dived in the rock quarry about a mile down the road, and it is where the rock came from to construct Interstate 64. So I'm very familiar with that as far as what lies underneath the so-called soil, because of very, very little soil. I'm here more to just try to give everyone an idea of the lay of the land, you might say, or more likely the lay of the ledges, the lay of the stone that is underneath. And I did see a drill in there, air compressor, on a couple of days. I did not witness any drilling per se, but then after a few days, that equipment was removed from the Huffman property, gone. Haven't seen anyone over there since. So, and I'm not going to get into whether that was construction or not. Again, I'm a veterinarian by training, so I'm not an engineer or anything like that. That said, I've built a whole lot of fence and drilled a lot of post holes with an auger that's about 6 feet long, and know that a lot of times you only go down 2 feet and hit rock, and that's about it in that terrain. And that is what the nature of that land is like underneath of what little bit of soil is there. It's pure rock. So that's really the only statement that I have to make to you today. Thank you for the time.
Thank you.
Any other comments from the public?
Go to the, if anyone is online and like to make a comment, please utilize the raise the hand button now. Not seeing any, I'll turn the floor back to the chair.
Thank you. All right, with no further public comments, we'll,
Absolutely.
oh, yes, sir.
I'm Alan Stout. I live on 136 Warm Run Road. And today I overheard a couple of comments that I just want to, that bothered me today. There was a construction, Sun Tribe's here. The construction company representative did most of the explanation about the racking company. Okay. His words were exactly, this is the construction company. And I think this supports the fact that the drilling out there was pre-construction, okay? He said, he made this comment. We asked our racking provider to give us a plot, and we have decided to go with the recommended plot they provided. So this is a construction company asking a racking company to come out and to determine how deep and what kind of racks they need to go in there and measure the pressure by poundage. I mean, and another comment was made by Tyler himself. He made a comment that APR racking was performing pre-construction activities. And I've looked on AI, and I looked at the normal construction process and the sequencing, and the racking company at work that they did comes way down in the construction process. Okay, so it's kind of funny that you have a construction company and a racking company is responding to them to determine how they're going to actually build it. That seems to me pre-construction. And we have laws that Bill has already mentioned. So I just think those two comments, and I was there. I heard the drilling. And it's interesting too, because, and I sent pictures about the smoke, and then they claim it's rock. Well, it's interesting. They were there for a day and a half, and there was none of that. And then at 3:30, just before about, 3:45, before they're getting ready to end their work that day, that was the last day, I hear a big explosion. Okay, I'm outside, and I look around, and the chickens I have, 20 of them, jumped clean up off the ground. And I looked around, and I saw a plume of smoke go directly up. And I got my phone, and it was windy. And I wish I could have got the picture when it went straight up. Okay. And maybe these drilling, maybe they create a bang, but that's the only bang in the 2 days that I heard. It's kind of weird. And not just I heard it, another person heard it too. So there's two of us that heard it that day at that time on the 16th of December. And we asked, and John actually told us in response to one of my emails he suggested, the fire marshal. Well, I sent a FOIA to the fire marshal, and this happened on the 16th. Well, they didn't come out until the 7th of January. Okay. Well, of course, there was no activity because they ended that day. So all I'm just saying is, I think we have a problem here, and I hope you guys will do what's right here, and we can go back to the Board of Supervisors and do this process right. That's all I'm hoping. Anyway, thank you for your time.
Any other public comments before I close this? Okay. At this point, we'll close the public hearing. At this point, I'd like to allow the board to discuss it. Are there any board members that would like to open up any questions for the discussion? Or bring up any points?
I guess from my perspective, it would be nice to have an explanation of his concern about the smoke or the dust or whatever that was created from his picture that he has presented. I mean, causes of that, just so everybody kind of knows your response to it.
Would you like us to give an explanation?
Yes, just so everybody understands exactly the reasoning for what that was.
Yeah, if you look, there's the APA racking company actually provided a letter, and also the Terraform, which represents Warmer and Solar, provided letters which describe what happened. What they said is that they actually use and would it be appropriate to ask when the Terraform people are here to explain what happened? Because they're actually sitting.
I just wanted to explain to the larger group.
So what happened was that they use actually from my understanding is pneumatic or air pressured hammers that drive down into the soil, and sometimes when they hit down lower, it results in a large sound. And then of course, they use air to blow out the dust, which is in the holes, in order to be able to test that. And so the plume that comes up is actually the dirt and the rock dust that's going up in the air. So that they said in their letter, which is in your package,
right, I just wanted more to the group.
It states clearly that that's a normal thing that normally happens when they do it. And as Dr. Showalter mentioned, there's quite a bit of rock under there. And so if that gets hit, it's going to result in rock dust, and the air will blow that out. And we did see the pictures. This picture show going quite high. And so it's understandable why Alan Stout, Mr. Stout actually thought what it was. But we have no evidence, and we take that very seriously. As a matter of fact, when that complaint came in, we actually, Spencer Suter, our county minister, sent a cease and desist letter out immediately to the racking company saying stop all activity until we figure out what's going on. Yeah, it's actually was the day that he received that information that he sent that out. He reached out for a call. So yeah, but that's a good question. We have no evidence, and I don't think there has been any evidence that explosives were actually used.
The test holes or the what was done on site, was that done in a particular locations, or was it somewhat random in the field? We went and saw one of the holes today.
Would you mind if one of the, it's up to you, but if one of the Terraform when people came up and said that, or is that something you feel comfortable answering? Yeah, typically. You need to come up to the microphone. If you could introduce yourself.
Absolutely. My name is Tyler McGilver with Terraform Power. Appreciate being here tonight and y'all coming out to the site with us. At the site, we had Marcus Grimes with Sun Tribe EPC. He was the one that was showing us the test locations. He wasn't able to be here, but his colleague Tyler Dick is also with Sun Tribe EPC. I'll let him introduce himself, and he's best person to answer this question for y'all.
Yes, my name's Tyler Dick. I'll be the project manager for the permitting, design, and construction phase of this project. The locations are chosen to be indicative of typical conditions of the project. The intention is to ensure that we're testing to understand the subgrade conditions to inform a design that will last the life of the system. This is critical to the integrity of the structural characters of the project. This to ensure that if there's major winds or any other disturbing event, whether natural or otherwise, that the system is strong enough to endure. So we do indicative locations throughout the site to ensure that we are making responsible decisions during the design process.
So the locations you chose earlier are not the same locations that post will be in the final design.
Not exactly.
You will not reuse any of those holes?
No, sir. It's just informative to inform the design to make sure everything's strong enough. And then during the construction process, the actual construction process, the array will be placed and spaced evenly, and never in my experience has a prior hole been used.
Thank you.
So,
Mr. Tyler,
Yes, sir.
I had a couple questions just before he leaves the mic there. Just for clarity, how many test holes did you drill?
I believe it was 28.
Okay. And then how deep are the test holes?
It can depend. I believe my understanding is we went down up to 8 feet. But again, the intention is to make sure that we understand what needs to happen underground subgrade in order to secure the system for the life of the system, which generally can be 25 to 30 years.
Mm-hmm.
So a lot of structural integrity is required to ensure that not only the system itself, which is holding electrical equipment, that needs to be very sturdy and reliable, but ensuring that that has integrity and nothing will become loose and become a projectile in the event of a major wind, like a hurricane gust wind or something like that.
So up to 8 feet, that's the deepest they would drill.
Yes, sometimes it can be more, but I believe in this instance that is the case.
Okay, thanks.
thank you. Any other comments?
I've got a few if no one else does. Been taking notes on my phone just so everyone knows I'm not texting my wife. I want to thank Mr. Russell for your thoughtful comments that I thought was helpful to add to the public discussion, as well as the public commentary. I wanted to clarify the statute. So question for Chris, I guess, from Mr. Russell, I wrote this down. He said the statute contains no exception for testing. Is that true? Because I'm thinking like when I get a building permit, if I need to go perk a septic system, you get a backhoe out there, you dig some test holes. You don't dig 28 and they're not 8 feet deep. So there's some caveats there, but I'm curious about that because that's a lot of what this is hinging on, I feel like.
So I can answer with this via email, and this was an email from Monday, December 15th. That's in your package. Sent at 4:01 p.m. To his defense, he does start by saying, I'm going to rely on AI citations and comments because the time is short and the harm is ongoing. But with that being said, the next statement is under Virginia law, and I'm quoting this, under Virginia law, comma, land disturbance activity is defined broadly and includes any man-made change to the land surface, comma, including drilling and excavating. It goes on to say that installation and removing of ground screws or piles for rack testing involves the drilling into the soil and therefore falls within this definition, regardless of whether the holes are later backfilled. And in Virginia Code Section 62.1-44, period 1551. That one, the actual quote from that land disturbance or quote land disturbing activity means any man-made change to the land surface that may result in erosion sediment or that may result in soil erosion or has the potential to change its runoff characteristics, including the clearing, grading, excavating, transporting, and filling of land. So there, and also could piggyback if you have it's my understanding that if you have a land disturbance permit for a single family dwelling, your building permit includes some of the land disturbance activity, such as a drain field. I don't think that is now, certainly you would not need a land disturbance to do a perk site. Test for,
right.
Yes.
And one thing to keep in mind on this, the actual question before us is whether construction started, not whether there's a land disturbance and whether land disturbance permits are needed.
Yeah.
And that is not by definition construction, because you have land disturbance. As anybody who's involved in construction knows, you can get the permits from the land disturbance permits or other things for stormwater issues.
Well, and I think it's interesting though that Jonathan
Griffin,
thank you. Said that there weren't permits necessary, but I still think that's worth just fleshing out.
And I will add to that, I did confirm that 2 days after receiving the concerns associated with site. I explained to Jonathan, it was my understanding at the time, it was 3.5-inch holes throughout the property. I'm not sure, I can't recall if I knew there were 28 of them or not, but I do. I had been by the property twice at that time and did a roadside inspection. I did not go on the property, but I went down Lincoln Road and looked over there and could see the cows, could see everything else. I did see any land disturbance from the portions I could see from Lincoln Road.
And it's the county's position, even if a permit was needed, that does not necessarily the beginning of construction either. There's a quite a distinction. I think the ordinance itself, it sets the standard. So pre-construction clearly is not construction under the ordinance. Excavating, they actually put in the pre-construction area too, which is not construction under the ordinance.
Similar to that, but separate. If we go back to the special exceptions permit, that condition number 11, it's 2 sentences describing 2 different kinds of work that and when that can happen. The first part is all pre-drilling foundation work or hydraulic hammer shall be limited to these hours. And the second part of that is all other excavation and construction deliveries and so on in those hours. So I think the special exception permit is also allowing for 2 different phases of the project, the pre-construction or the testing, and then the actual construction.
Another question. So the $30,000 surety, it's possible I missed this, but when is that? The project owner needs to provide that. Is that something that has been provided, or is there, when is the timeline on that? Just to clarify?
Prior to the beginning of construction.
Okay.
But
And a little bit more nailed down on that, it would be prior to there is a building and zoning permit required for the construction of this. And so that would be, a lot of these, the majority of these would take place prior to the zoning community development official signing off on the zoning portion of it. That's sort of our checklist. And you'll notice some of them are after the construction is done, that some have to be satisfied.
So unless it's determined as construction, the $30,000 bond does not need to be satisfied.
That is correct. And it states in number 21, prior to commencing construction activities, comma, that project owner developer shall provide evidence to the zoning administrator of a surety. And so my threshold, the same thing with the decommissioning agreement, same thing with the majority of these would be required to be satisfied prior to the zoning department signing off on the building and zoning permit.
And then after that, they can commence with construction.
Absolutely. Yes. Yes, sir.
And then there's a $45,000 trade permit to be approved by the county.
That would be 3 months after ones. That's one
Yeah.
that is after the construction, if you will. Yes.
Okay.
Well,
After-
it would still technically be into construction. I'm not sure how long of the construction activity. It could still be under construction. That's correct.
Okay.
And same thing, I would go ahead and just add, go off that subject line is number 17. The project owner shall, within 30 days of activation of the solar facility, contact the chief of Department Fire Rescue Management to coordinate, a facility walkthrough for preparation and training as it relates to emergency responses to fires. And so that's another example of the thing that would take place, conditions that would have to be satisfied within a certain amount of time after. That's after everything is done on that particular one.
Mhm.
It's hooked up to the grid and it's producing electricity in that case.
Any other questions or comments of the board? Does anybody want to make any recommendations? As to determine if this was construction or pre-construction? Or any other questions surrounding?
I think on the agenda now, you have the opportunity to go into closed session to receive guidance by your
Yes.
attorney prior to making decisions.
I can make a motion that the Rockbridge County Board of Zoning Appeals convene in closed session to discuss the following as permitted by Virginia Code 2.2-3711A7, a matter involving consultation with legal counsel about the pending case of Warm Run Citizens Association LLC and Rockbridge Taxpayers Alliance Incorporated.
Is that a motion?
Yes.
Second?
That was Mr. Vest, second that?
Yes.
Okay, thank you.
All in favor?
Aye.
Opposed?
Aye.
Aye.
All right.
All right, so go ahead and,
That was just to clarify for record, that was a 4-1 vote.
that was 3-2.
Okay, could you go ahead and just take a roll call vote from the?
Yeah, roll call vote.
This is to end the public hearing and open the,
Go into closed session, a motion to go into closed
Public
session.
hearing.
but everyone can stay. Sorry to clarify.
Yeah, the public hearing was already closed. This would, a closed session, which will enable you, this is your attorney, to actually ask him any questions or receive any guidance.
But the public is present
No,
for
no, the
that.
public is not present. The
Oh.
closed session.
I'm sorry.
Would for everybody to leave the room. That's what it's for. So you'd have
Sorry.
yours.
Thank you for clarifying. I would say,
And when done, we will invite the public back.
Yeah, and you have to follow, by law, you'll see the outline. There's certain things that you have to proceed with, and you cannot take any votes during the closed session. And your attorney will guide you on that.
Just to get clarification.
there's just one more thing I'd say then. Can I make a comment before we
Sure.
pass the motion? Just to say that I'm a neighbor to a solar array, and I resonate with the concerns of the public on all of these things. And our duty as the Board of Zoning Appeals is just to look at what the law can do and what it can't do. So I would just clarify that all of our conversations we had, Vivica kept track of when we were on site today, and that there's complete transparency with the process, and that as a citizen, I think we all are doing our best to just honestly look at this and see what the law can do. Thank you.
Okay,
So with that, and not to chime in, but there's a motion on the floor by Mr. Mullen, seconded by Mr. Vest. At this time, the chair will call for a roll call vote.
roll call vote.
And this is,
Aye.
And I abstain.
okay. Good.
Yeah, that's okay. So now we need to, everybody needs to step out of the room, and then they will reconvene afterwards, and that's when they'll have the opportunity to make a determination of postponing.
I take it. Hey, Spencer. I need you for a second.
We're gonna meet in here.
Well, I'm not dealing with the audio, so I have to put a mute up there probably.
Zoom closed down.
Right.
Oh, no, yeah, you need to mute
Yes.
that and turn the camera on. This is you, right?
Yes, that is me. But I'm now the co-host. So I think I do it from here.
What's that?
Miracle.
Oh.
Mr. Powers be with us momentarily.
Okay.
Few seconds.
Okay. We need to make a motion to return to open session.
Move that we return to open session.
Second,
Second.
all in favor? Aye.
Aye.
Okay. I move that the board certify in the closing session meeting that was just concluded, to the best of each member's knowledge, nothing was heard, discussed, or considered except for the matter or matters specifically identified in the motion to convene in closed session, and two, lawfully permitted to do so, discussed as exempt from open meeting requirements under the provisions of the Virginia Freedom of Information Act cited in that motion. Does anybody have any additional comments or questions that they want to discuss?
I think you need to vote on the certification.
Oh,
Good.
I'm sorry.
I'll second.
Motion to,
Second.
yeah. Roll call vote
For-
to return into session.
For the certification, that everyone agrees certification, because if anybody objects and thinks there's things discussed during the meeting that aren't
Yeah,
true with
okay.
the certification, you have the right to make that known now. So
So I can make a motion to certify.
make a,
Yeah,
I second.
all in favor?
you need a roll call
Aye,
vote.
roll call vote.
Aye.
Aye.
Aye,
Aye.
thank you. Any additional comments that anybody would like to have for the discussion following our closed session meeting? No? Okay. Would anybody like to make a motion based on what we've discussed?
I move to dismiss the appeal of Warm Run Citizens Association LLC and Rockbridge Taxpayers Alliance Incorporated for lack of standing. Neither applicant is a person aggrieved as defined by Code of Virginia 15.2-2311A.
Do I have a second?
I second.
All in favor?
Aye.
Aye. We do a roll call vote for this as well?
Aye.
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 All right. Any other business?
No business at this time from staff.
Okay. This meeting's adjourned.